Well, hello, everybody. Welcome. Thank you for being here today. I have a lot to show you, a lot to talk about today. Thank you so very much. Let me go ahead and get us going here. I'm going to pull up our screen and I'll try to make this quick. Hi, Deb. And thank you for being here, Deb. And Holly, welcome back. Renee, Stephanie, boy, we got a cast of celebrities here today. Thank you all for being here. So we are at the Greater San Diego Association of Realtors, and my name is Kevin Burke, and there's my telephone number, and please feel free to call me anytime. It rings wherever I am. And then there's my email address, and email's good. You know, I like talking, to people, but if the email is something quick you want to do, then that's fine. I think I just realized I owe somebody a form. A few minutes ago, I saw it in my email. So I do get a lot of emails. And so anyway, I want to make sure that you're taken care of, and I want to make sure you're taken care of quickly. And by the way, if I don't respond to you pretty quickly, so like today, I'm doing this webinar until noon, and then I'll have a 2-hour break. And then I'll do it again, a different webinar from 2 to 4. But if I don't get back to you today, would you please let me know again? Because I feel bad that people say to me, they say, "Well, I really didn't want to bother you," and I say, "Please, I feel bad. I mean, I want to help." So please, be consistent, be persistent, and reach out to me with a second time. There's no harm in that. Now, 3 minutes later, probably not. But obviously, right now, I'm not going to be able to respond until noon. But happy to help. Okay. And I don't know, is Yolanda here today? Yolanda's not here. She asked for something last week. If don't bother putting your email address in the chat box, because I lose all of that when I close the webinar. So, but anyway, let's carry on. So I'm a broker. I have a broker's license in several states. I do teach continuing education for attorneys, MCLE approved classes, and I've been teaching that for 25 years now, and or 20 years. I think it's 20 years. So, but I like what I do. So, what the heck? And today we're going to be talking about forms. So on the right-hand side, you see I have added chair of legal affairs for next year. Kind of jumping the gun on that, but I'm very excited about that. I was asked to chair that committee. So got a lot going on up there. So let's move forward. We're going to be talking about stuff today that's going to appear to be legal. I am not a practicing attorney. I have absolutely no interest whatsoever. I assure you of that. I work way too hard and we make more money, so it's all fun. So anyway, I do a lot of trial work, limited to testifying as an expert witness. And again, that is a court certified expert witness, so it is a title. The DRE again says you may not call yourself an expert except in a title, so like a certified distressed property expert, or in my case, a court certified expert witness. Mostly standard of care. Did the agent do what they were supposed to do? And I'm a big risk management versus damage control kind of guy. So if you got something, you need to be talking to your broker if there's something that concerns you about what's going on. And you can always call me. I'm happy to do it. But again, sometimes it's going to be subject to broker policy. So I may end up kicking it back to the broker, but you can always give me a shot. Agents' duties of inspection and disclosure, and then finally market conditions in San Diego County, at least, although I'm asked to talk in other parts of the country as well. So the other parts of the country other than San Diego country. So anyway, conversation not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Okay, so our webinars are intended to be interactive. Please utilize the Q&A button to ask questions or offer input, and I do look forward to hearing from you. It really kind of makes my day when I know I have an active group participating in things. So this morning we're going to talk about new and revised CAR forms. And there's plenty to talk about, I can assure you of that, but I want to show you some little tricks of the trade that will make it easier for you to find these in the future. So and then this afternoon we'll talk about leases and creating amazing lease templates. I'm going to show you how to do that, but I'm going to show you for leases, but I'm also going to show you generally on how to create a template. So and we'll see in a minute that we're driven by templates. Our whole office, the whole company is driven by the use of templates, and I'm going to show you why that's really, really important. So then we take a break. Monday is, of course, the Labor Day. And then on Tuesday, they don't have me scheduled to teach anything. So Thursday, I'm back teaching how to create the ultimate listing agreement. And then in the afternoon, I'll be doing a benefit overview, the MLS rules. I was rules chair at one point. I don't know if I still am or not. I haven't had a calling to do anything with it, but okay. So today we're going to talk about member benefits. And so I want to thank you for joining us. The June 2023 new and revised CAR forms. And so specifically June the 26th at about 1:30, and I was sitting in there hitting the refresh button, even though I knew what was coming. For the most part, they give us the red line version, and then they sometimes between the last red line version, and I've got the most current version of that, and when they actually release the form, sometimes there's some modest changes and stuff like that. But by the last release, they pretty much got it dialed in. So I'm going to show you the new forms, and I'll show you why they're the new forms. And then I'm going to show you the revised forms as red line versions. And I also have them available in my template, of course, to show you as the final version of things. So I always say, yes, there's a form for that. So I want to take a look at a couple of standard forms website locations. So we'll come back to that slide in a minute. But in the meantime, I want to take you over to a couple of places that are going to be kind of important for us. So the first place I want to take us to is this, whoops, wrong. There we go, is the CAR website. So from the CAR website, folks, you see here where it says Transaction Center up here at the top. I'm going to click on Transaction Center. I'm going to go down here to Standard Forms, and I'm going to click on Standard Forms, and then it's going to take me to the Standard Forms page. I'm going to click on Forms Revisions and New Forms Releases. And here they are. These are all the releases. I talked CAR into leaving the red line versions up so that people could compare them, do notes and things like that. Well, let's take a look right here, my June 2023 quick summary. I'm going to pull that up, and you all see in here, these are the forms that were scheduled to be released. Looks like they were released on the 27th, so they were scheduled to go out the 26th, and we actually made them hot at 1:30 on the 27th. And so they, like I said, again, they give them to you, in the red line version. So we have the quick summary guide. So I'm not going to pull that up right this second, but we'll talk about that later. And then I see my new forms, and so here's the thing. The new forms are going to be my CRB and my CRS. And so in the old days, prior to the June release, we had a contingency removal form. It was the CR form. And what we've done now is we bifurcated the form into two. So now we have the contingency removal for the buyer, and then we have the contingency removal for the seller. And I'm going to pull those forms up here in just 1 second, because I want you to see that there is a significant difference. We just got to a point where we couldn't keep it on one page anymore. And again, it used to be that the bottom of the contingency removal form was the part that the seller would remove a contingency, but it created more confusion than not. And since we're not really subject to the Paperwork Reduction Act anymore, because all of this is all mostly on the internet, we decided to go ahead with the splitting up the two forms. Then we have the RPOQ, which is a form that we created that was the rental property owner. So RPO is rental property owner, so it replaced landlord. And then it's the questionnaire. So there was an RPOD, which was attached to the new property management agreement, in which case the owner of the property, the rental property owner, as we call them now, would disclose all of the items that were of interest on the subject property. And so because we realize there's a lot of statutes that apply to rental properties as well. Now, our focus today is not going to be as much on rentals. I'm going to cover a lot of that this afternoon, but we have plenty to talk about. And then finally, my RUPA form, which is going to be my residential unit purchase agreement addendum. So anyway, I wanted to show you how to get to this. This is the whole point. In December, this will be the December 2023 forms release. But let's take a look. I want to show you. Let's go over to the can you see that? No, you can't. So good. I put my computer behind me for some weird reason, so now I have to double check behind me rather than to the left of me, which is where it's going to end up after we're done with this webinar, because I'm tired of looking that way. So anyway, and we have a whole bunch of new people coming. Thank you for being here today. Okay, all right. So this I wanted to show you. This is let me back out. I want to go back to my list. So this is our list of templates. Okay, we are driven by templates. Templates are really, really important for us. And so when I go to look, one of the reasons we use the template is that CAR will update the template that we have on our computer with the new forms. They will not touch a transaction in progress. And we'll talk a little bit more about that later. But when I go over here to the forms, I'm going to pull up the Editor Classic. When I'm over here, can you all see? Yes, okay. So here's the library. This is the forms library. And I'm going to click this little drop down right here where it says all. And then I see down here my form update for 623. So what we've done is we've put all the forms that were updated into this place. They're still in the other places in the forms library, but we created a place for them so that you would know these are the ones that were updated. Okay, and so one of the things that, again, notice that they all say 623. That means these were the updated forms. We're going to talk about these forms today. Not all of them. I mean, a lot of them, like modification of listing, there's like 6-7 versions of it, so we don't need to do that. But we are going to talk about the important stuff and touch on some things once. Notice of entry, there are 5 of those forms, but they all say the same thing. Okay. All right, so going back up here again, folks, right there where it says form update. Does everybody see that okay? I wanted to make sure that you knew where that was. All right, so this is the part I'm usually looking for when I'm getting close. So when we get close to December, I think we're going to be December the 18th or thereabouts. In fact, I have it in my PowerPoint. So let's take a look. So I wanted to show you how to get to those red line versions. So we looked at the red line versions on the CAR website, and then we looked at the final versions in the Zip Forms website. Okay. All right. Now, please remember, always be sure to use the current forms. Now, I know it goes without saying, but I'm telling you that if you are copying transactions, you are likely not using the current versions of the forms. And there's a lot of reasons why we want to use the current versions, okay? Because the current versions offer you some protection. It's called the User Protection Agreement. So CAR will support you in the event that you get sued on the pre-printed language of the forms. Now, mind you, what that really translates to is that at the appellate level, so you lost at the lower court and now you're in the appellate court, they will write an amicus brief, which stands for friend of the court. So they'll write a letter on your behalf. That's essentially what they're going to do. And of course, I love CAR, but for me, it's like, okay, they make a lot of hoopla about the user protection agreement, but listen, it's better to have it than nothing, right? And so they're not going to send lawyers down on your behalf. I mean, it's going to be something that they will coach you on it, or your broker more likely. Okay, so always be sure to use the current forms until the new ones are officially published. Do not use the red line versions, okay? And again, they're going to be published the week of the 18th of December. So we'll have new forms coming out. And so I probably should say, and I didn't put it in my PowerPoint, I'm thinking I should have probably done that, but why do we publish new forms in the first place? And the reason is simple. They're in response to litigation, right? So lawsuits create changes in the form sometimes. Things that not that the form was bad, it's just that something happened that we thought maybe there's a better way to say what we said that would prevent it or help to prevent the lawsuit. But the second thing, so I call them the 2 L's, right? So litigation and then legislation. And so the laws change twice a year. They usually take effect on January the 1st, and then they take effect again on July the 1st. And so that's why our publication in December, at the end of the month, is, when we're not quite as busy. Some people aren't busy. I'm slammed. December, folks, is my best year, right? I mean, people just coming to me all the time in December because can't get a hold of anybody else. And, I'm trying to get rid of the business. so anyway, so we publish the forms that week in anticipation of the new laws that are going to take effect on January the 1st. Now, and then why did we do them on 6/27? Well, we did them on 6/27 because on 7/1, that's when the new laws take effect then. So they take effect on January 1, they take effect on July 1. So we know what they're going to be because we've been lobbying for a lot of them. And so then we just create the form that accomplishes that objective. Is everybody okay with that? When the new revised forms are published, be sure to use the new revised versions with new transactions, okay? And so the easiest way to do that, again, is to create a template. And if you've created a template, then again, we'll update the forms for you. So we won't add new forms to your template, but we will put all the current versions in the template. So if you're doing let's say you write an offer for a buyer and you write it for them on on June the 1st. You write an offer for them from scratch, I'm assuming, on June the 1st. And then that deal doesn't come together. And then on July the 1st, which, remember our form's updated on the 27th. So on July the 1st, you write another offer for the same buyer. A lot of your forms in your offer are going to be dated already. They're already going to be out of date. And so you don't want to do that, right? You want to apply a template to the transaction so that now you have the current forms. And when I'm teaching the zip form template class, I usually show you that if you're using a transaction that you just love, then make a template out of it, right? Because if you make a template out of it, then we'll update the forms for you, okay, at the appropriate time. So on June the 27th, and then on December the 18th, we'll update your forms. So, so that now you're constantly so I update my templates twice a year. Listen, I take this business seriously. So I update my templates twice a year. And when the updates, when it's time for that to happen, I spend a whole weekend on it, doing all the new forms and everything, and the revised forms, and I apply it to the template for all the transactions that we create as a company. Okay, all right. So that being said, do not replace forms in an active transaction. I'd say don't be doing that, right? Because it's you might have had them sign, for example, a contingency removal form. Why would you go back and have them sign a contingency removal for the buyer form? Why do it again? It wouldn't make any sense. So plus, if they haven't signed a form, then it's okay to use the new form. But once you've had it signed, leave it alone. Everybody okay with that? Any questions on any of that? It's kind of an important concept. Okay? Nope. All right. If you have a question, please ask. I like answering questions. So do not replace forms in an action without your broker's approval. Talk to your broker. But it could very well be that the broker's going to say, you know what, you're fine. Because again, that quick summary tells us whether it's okay or not to use the old form. Okay. All right. CAR will not change or add forms to a transaction you have in progress. And I said that before, and it's really important. I had a broker who sent me a transaction to review, and I was looking through it, and I found an old DA form, which was the old disclosure and consent for representation of more than one buyer or seller. Well, we replaced that form back in what was it, 2012, right? So over 10 years ago. And so we replaced it with the PRBS. So it wasn't the DA, now it's the PRBS, which is the possible representation of more than one buyer or seller, disclosure and consent. Okay, so that's a different form. All right, so anyway, so we're not going to change the form, and this person was copying the same one, just really liked what he was doing, so he kept using the same one again and again and again. I'm going to tell you, it's very dangerous. You want to be sure you're using the current form version. All right. Okay. So they're not going to change or add a form to transaction you have in progress. If you've created a template, they will update your template. Obviously, they're going to update the library for sure, and then they're going to update your template. Okay. And I'm going to show you how important that is. They're going to update it with the revised form. They will not add new forms to your template. So, for example, when I went to my buyer offer template, I noticed that my BRE was gone. My buyer representation exclusive agreement was gone, but there was also no BRBC because that was the form that replaced it. Well, they're not going to put that in there because that would be a new form. So that they took out the BRE, and then I had to replace it with the BRBC. Same rule with the contingency removal. So the old CR form didn't exist anymore. So they pulled the CR forms out of the templates, but I had to go then and add in the CRB, the contingency removal for the buyer. Does everybody understand that? I mean, I'm more than happy to repeat it if you want me to, if there's an issue with that. So the library will always be current. So, but I'm going to tell you, why would you create transactions from scratch every time. I mean, you really need to create a template so that the transactions will essentially create, fix themselves. Okay, and again, that's going to be kind of the fun part about the staff news class. But okay, so let's take a look at the Zip Forms library. And I put in here, please review my webinar on how to create DRE compliant templates. And what else? That's the QR code reader, so we're not going to go there yet. So let's go ahead. I want to pull into the library really fast. And then here I am again, the forms library. So I'm going to go now, though. I want to go over to my template. Everybody see this, the template button? Yeah, you can see that. Forms and checklists. I'm going to go into my templates. So here's my templates. I have new agent hire template. We have this class is saved as a template. Okay, and I'm going to show you how cool that is. We have the seller listing template. We have the buyer offer template. We have the property management, and then I have classes that I have done and things like that. Lease templates. But whenever I do a class, I usually create a template for it. I even created a template when I did a talk for the Department of Real Estate back last year. And I was asked to do a 4-hour webinar on the RPA. And so I created a template for it. It's going to change, right? The form will be a different form today because the RPA will be in there. But, if I'm, asked to come back, maybe I don't know if I was that good or not, but if I get asked to come back, I'll have it ready to go with a new one. Okay. So that's all good. All right. So these are my templates. I'm going to go into my new and revised forms template, which I created. And here it is. And they're always going to give you this stuff. I created it as a purchase template. Only because the program didn't allow me to create what I wanted to create. So I had to work around it. So here I am, and this is my CAR new and revised forms. You'll notice up here, I have my December 2022 forms. Now, because they're in the template, they're gonna update the forms, right? So they'll say 2023 on them now if I open there. But the point I want to get to is right here when I'm looking at my June 23 forms. I've got my new forms and I've got my revised forms. So let's take a look at my and notice that under revised forms I've got them categorized: purchase agreement, listing agreement, and lease agreements. Okay. All right. Now again, you don't have to go crazy with this. I only did this so that I would have them all in one place and that it would update the forms for me. If I was going to do a transaction, then I would already have created a buyer offer template. Let's take a look at that really quick. I want to show you. So here's my buyer offer template. So we've already written the buyer offer template. Over here on the left-hand side are the folders that we use. Over here, so you see one folder is the BRBC. So we created a new buyer representation broker compensation agreement. So I'm going to click on that really quick, and you see all the forms we send to the buyer at the time of listing the buyer. Okay. If you're not comfortable with the buyer representation agreement yet, you need to get really comfortable with it. I'm telling you, I was in a very high level meeting last week with CAR, with the big brokers were there. And we had a conversation that we were going to make the buyer representation agreement a legal requirement. We were introducing legislation. We just thought it was too soon. So I wouldn't be surprised, folks, if this doesn't become the law on the 1st of January. I can tell you I'm a broker in Virginia, and July 1st of last year, they made it a law that you had to have a buyer representation agreement with someone. Otherwise, you were giving them legal advice and you were not entitled to be compensated. So that's coming. So I'm telling you that here, and hopefully, that helps you to get past maybe whatever anxiety you have. I mean, I have whole companies that I was doing a talk for a brokerage, and one of the agents got up and said, "I'll never do it." And the broker got online and said, "You are going to do it. It's our company policy." And so, wow. So, it's a company policy in a lot of places. Maybe your broker's not doing it or requiring it, but you need to talk. You need to find out more about it because it is coming. Okay. So there'll be a whole great big panic. I mentioned earlier, my RPA class was approved by the Department of Real Estate for 5 hours of continuing education. I'm just trying to get on SDAR's calendar to be able to teach it. They've also got my buyer representation agreement up in front of them for approval. And then they've got my listing agreement coming next. And so I'll be doing classes for DRE approval. The BRBC and the RLA will be 2-hour classes each, but the purchase agreement is five hours. And so just be aware of that. So anyway, this is what our template looks like. We have a place for pre-approval letters. Obviously, there's none in there right now because this is not a live transaction. Property info is where we put information about the MLS, or we always run an RPR to figure out the value of the property. And then we have a link for the offer. And so notice that we have all the forms in here, and we have all the new ones. So, you know, when I'm going through here, I see 623. I see it's not the only one in our offer that was changed. So let me see what else I got up here. Statewide buyer and seller advisory was updated. We're going to talk about those in a minute, but I did want to show you that. Okay, so I'm gonna get us out of that. I want to take us back to our new and revised forms, and I want to go to June, and let's take a look at the new forms. Okay, everybody. So we're going to take a look at the new ones now. For that purpose, I'm remembering now that I actually did this in my PowerPoint. So again, I have a webinar on how to create DRE compliant templates, and I'll give you the link at the end of our talk today. Or maybe not. Here's the QR code. So if you want to take a picture of that, I'll give you a minute. Take a picture of that. It takes you right to the webinar. Okay. Okay. Anybody have any questions about any of that? Okay. Always double check the revision dates. Okay, remember what I was just showing you, 623. Make sure you're using the current version. Again, we did 67 updates. Okay, we did 4 new forms. We did 67 updated forms. Okay, so just always check the revision date. Make sure you're using the current one. If you're taking it out of the library, then you know it's current. If you're taking it out of your template, then you know it's current. But if you're looking at a transaction that you've got going on, that you copied transactions, they're probably not going to be the current forms. Okay, all right. Okay, now the revision dates are at the top and at the bottom. So let me pull up one of those for you really quick. I'm going to pull up. Let's grab the. Well, those won't be here. Here, I'm going to grab a purchase agreement. I'm going to grab. Let me get a form that you all would be fairly familiar with. And again, we're not going to do all of these forms, but we're going to do quite a few of them. So I'm going to grab the vacant land purchase agreement. Just laughs and giggles. Here it is. Go to full screen. So up here at the top, it says 12/21. So we did not update the agency disclosure. We updated it, by the way, in October of 18 and then again in 12/21. But I want to go, so here's my fair housing and discrimination advisory. And so we updated that in 6/23. But we left the PRBS alone. We left the wire fraud advisory alone. Then I get into my vacant land purchase agreement, joint escrow instructions. You can see here's the date at the top, 6/23. And then I'm going to scroll down to the bottom, because here it is again, 6/23. Does everybody see that okay? All right, I just wanted to make sure that you were aware of all that. I'm going to go back. I'm going to keep that one in place here. Let's go back over to the PowerPoint really fast. So top and bottom of the forms. And then let's talk about the new forms. And so I want to show you the new ones. Now there's only 4. Okay, again, brand new forms. There's only going to be 4 of the new forms. Contingency removal for the buyer, which is the one we talked about a minute ago. So let's take a look at that. So how did we handle the contingency removal for the buyer? Here it is right here. Again, updated very recently. So I'm going to look at the form. Again, as I said earlier, it used to be the old CR form, the contingency removal form. The problem was all this stuff up here at the top was one thing, and then down at the bottom it had the part for the seller. Okay, so I actually do have the contingency removal form. Let me see here. I actually have the contingency removal for, let me see if I can get to it without taking up way too much of your time. I have the red line version. Well, they're in alphabetical order. Unfortunately, I don't see it there. So let's see, okay. COL. Nope, I don't have it there. So that means I'm going to go back over to my red line version of things, and I'm going to pull it up. CRB. Here is what they actually did. Good. Here's what they actually did to the contingency removal form in the last iteration. So they added including insurability. So remember that when your buyer removes their investigation contingency, they're also removing their contingency to confirm that they can get insurance on the property, or that the cost of the insurance won't take them outside of the lender's range of how much they can qualify for. Then we added fire, flood, and then we added others, a whole bunch of others in there, and that's essentially what we did to the form itself. Okay, so just so you know, I wanted to show you that change. And I'm going to take us back to our PowerPoint. So that was contingency removal for the buyer. And so that's the CRB form. Then we have the contingency removal for the seller. Let's go ahead and pull that form up. See, that's going to be the CRS form. And so what did we do with that one? You can't see that. So let me take us over to there. Where'd it go? Here it is. Okay, so this is the contingency, the seller's contingency removal. Notice CRS at the top and 623. So we really didn't make any huge changes other than references to paragraphs. Okay, and that was about it. That they did not highlight in red the date of that change. So, but then as far as the other forms are concerned, we're going to go back. Number 3, the above two are bifurcation of the previous CAR form CR. Then we have the rental property owner disclosure, which actually should be the RPOQ, the rental property owner questionnaire. And that form, let's pull that one up live, obviously. Going back, rental property owner disclosure. Nope, I got it right. So they actually had switched it around. The disclosure was attached to the listing agreement now, but they renamed it and named that one the questionnaire. And then this one is the one that you can actually give to the tenant. Okay, so this is the new form. And again, it's built to look like the SPQ form. It's built on purpose that way. Seller, are you the RPO? So one of the things I didn't tell you was, we changed the name of the landlord because CAR felt like there was a negative connotation to that, much like we changed, master bedroom to primary bedroom. So they kind of thought that there was some negativity in that. So they changed, a lot of our forms, they changed from landlord to rental property owner, otherwise known as our RPO. Okay, that's all. That's it. And again, that's why we're not going to have to go through a lot of the forms on the property management side, because that's really the only change that was made, and including the fair housing advisory disclosure advisory. It has the only changes were changed from landlord to rental property owner. Okay, and then we updated the form. So that's my RPOD. I like the form, by the way, because there's a lot of statutory disclosures that we weren't making on rental properties, like lead-based paint. That's huge. Meth contamination, things like that. Death on the premises is required by law, and we weren't doing it. That's California Civil Code 1710 for those of you who are keeping score. So I wanted to at least show you that. So then my last form is going to be my my residential units purchase addendum, and that's this form. This is a new form, and so again, as it says, it's for use for the commercial purchase agreement. So you're not likely to use this in a residential purchase agreement, because why? Because it contemplates units and commercial property. So usually, as you know, downtown we have a lot of the buildings, the ground floor of the building is commercial space, stores, things like that, and then above them we're seeing the units, and so it can also be used with a vacant land purchase agreement. Interestingly enough, I was in Boston last year, year before. There was a building that they were completing that had 66 stories of office space. and then another 24, I believe, of residences above it. And by the way, no parking. And so Boston's doing its best to get rid of automotive transport, essentially having everybody rely on either mass transportation or on ride share. The only way you can park on a street is if you have a permit to do it. So people that own, single family homes, they can apply for permits, stuff like that. So kind of an interesting form. Again, I like it. I think it's about time. We have a lot of transactions now that are utilizing this form. And so, and again, this is just the addendum, okay? And so some of the things that you got to have in this one that are included in the purchase agreement, like Megan's Law database disclosure, the law just requires that we disclose the existence of the database. We don't have to go to the database, but the vacant land purchase agreement and the commercial purchase agreement don't have those in there. But because this one's a combination that includes residences, we needed to add that to the mix. Everybody good with that? Anybody have any questions about any of that? Okay, moving back to the PowerPoint. So that's my, then we already talked about the RUPA. And so let's talk about the revised forms. So I would like to take a look at the revised forms. And oh, by the way, yeah, there's 67 of them. And so we're not going to do all 67. For those of you that are all excited to get to look at 67 forms, listen, I've gone through these. It seems like a lot, right? But we're going to tackle it by function. Fortunately, I have saved them in alphabetical order. And so we're going to look at these starting, actually, I don't think we're going to be able to do it this way: purchase agreement, listing agreement, and lease agreement. I will show you, how I have categorized it in my, whoops, wrong way. Okay, back, nope. Back here, the way I have categorized it in my program here, as you can see over here, you see that, yeah, I've got June 23. I've got the new forms. I've got the PDF redline forms, which I've opened the relevant ones. And then I have the revised forms. And inside revised forms, I do have purchase agreements. Here are all the purchase agreement forms. Here are all the listing agreement forms. And here are all the lease forms. So what we're going to do is we're going to go to the PDF redline because it's the most current version. I downloaded these after they made the last and final change to it. So we're going to go take a look at each one of these. Okay, so starting off with my far left here, again, in alphabetical order. We'll be able to spin past a bunch of these. It's not going to be we're not going to be doing 67 forms. But please, again, if you have a question, stop me, okay? So we have our additional broker acknowledgement and addendum. And so this is the form that you would use if more than one broker was involved in a transaction, whether, and again, it's an acknowledgement, so we want everybody to sign it. We want all the parties to sign it, that we've got more than one broker in the transaction. Again, different brokerages, I think, is the better way to say it. But then it's also an addendum. So in looking at this, I see for the listing agreement, if I have a listing agreement, I fill this out if it's applicable, right? And the additions to it are the commission breakdown. So this is on the listing agreement side. How are we compensating each of the brokers? Equally and jointly share responsibility, normally yes. Or what? Or it's a referral, right? So if you're not going to be an agent in the transaction, it might be safer just to have a referral fee agreement. And then, or we have a whole attached agreement, so I'm with the blue people and I do a lot of transactions with the red people. And so maybe I have an agreement between the brokerages for that. Then I would have that attached agreement here. And again, this is signed by the seller or buyer, and then the seller or buyer or broker. Okay. All right. So the other party. All right. Okay. My buyer representation agreement, again, if it applies, we're going to name broker number 1 and broker number 2 like we did up top, and we're going to have the same criteria in there. Purchase agreement. So now this is probably what you more commonly experience. The buyer is being represented by 2 separate brokerage firms. I'm sorry, that's the less common. The more common is usually 2 brokerages represent the seller. But where we have a purchase agreement, we could have 2 brokerages representing the seller or 2 brokerages representing the buyer. So they chose to create a whole new form. So check one box only. If more than one applies, then use a separate form. So 2 separate forms. Everybody okay with that? Multiple brokers representing the seller, multiple brokers representing the buyer, and then here's who the agents are in paragraph number 4. I love the way that that the lawyers put these things together. I mean, 3 years of law school for me, and I can tell you, it just changed your whole way of thinking, right? It's kind of like, I guess, joining the Marine Corps, right? I mean, you're going to come out of there a whole different person. I think a lot more structurally now than I did before. So remember, they treat everything in terms of an outline. So you have your paragraph 1, your 2, your 3. 4 is when you start having the names of the different brokerages officially put in here, along with their DRE number, because we've got to disclose the DRE numbers of the brokerage firm. Okay, so activity under the license of broker 1 or broker 2 or both, as applicable, will be conducted by multiple associate licensees, whether they're a sales associate or a broker associate. Okay, all right, and then if it's partners or teams, then we're going to use the AAA form, which is the additional agent acknowledgement form. So again, I actually had a lawsuit where the individual used the additional broker acknowledgement form. Unfortunately, the agent, it was a transaction coordinator, was not in that brokerage. They were in a completely different brokerage, and so they thought they were doing things right by filling out the form, and that was a big mistake because they made their own broker liable for it when in fact they really wanted to just be a transaction coordinator. Okay, so that's my additional broker acknowledgement forms. Anybody have any questions about any of that? I'm going to fly forward here a little bit. Again, I'm showing you the red line version, but if I go back over here to my forms, if I go look at my revised forms, where did I put it? I think I've got it under purchase. So here it is, additional broker acknowledgement. So this is how it's going to look in your transaction, right? So you're not going to see the red line, but here it is. And so pretty much fast scan here. It's pretty much the same thing as what I just showed you, but in the red line version. Okay, so I wanted to show you the red line version so you can see what changes we made, because there were some changes, although they weren't, and they were enough to keep the form as a revised form, not as a new form. Okay, everybody good with that? I'm looking here, misspelling of the word commission. Okay, well, it happens. They don't consult with me on these things. So let's go back over to my forms again. That was my additional broker acknowledgement. Let's take a look. I pulled this one up just to give you an idea, and the reason I did was because we're actually going to have, we're going to talk about a bunch of forms. Hey, Joe, we're going to talk about a bunch of forms that are just redundant. So I don't need to show you, I'm going to show you the RPA, and then you'll understand the already built subdivision, because a lot of the changes really just trickled down to the other purchase agreements. That's all that they did. Okay, so I pulled that up for you, and there's my revision date up at the top. And then as I scroll down through here, I'm noticing no changes, except for obviously the revision date. And then we have the return of the deposit. So we'll see that change in the RPA shortly. But the big one for me, which they ended up saying they were going to do and then they didn't do it, was the solar power. So here it is. So here they said in the red line version, they said we're going to change solar systems, because in the purchase agreement it looked like we were able to buy sell planets. So because it said solar system, so we're going to sell the Milky Way, we're going to sell the Andromeda strain, whatever. But they've realized, probably watching my webinars, but they realized that it should have said solar power system. So we see this throughout all the forms. And then I'm going to tell you they didn't change it on the RPA. So it's actually paragraph 11M, I think 11M in the purchase agreement, but we'll see that in a minute. So anyway, not many changes there, right? So it's nothing I'm going to really write home about, nothing I'm going to jump up and down. You can see I'm going page by page by page, and there's just no changes. Under seller warranty, and some of you will remember back before October of 02, I was way into practice at that point. In fact, I had my law degree at that point. But in October of 02, we used to have in the purchase agreement, we had active, passive method of contingency removal, which we got rid of that in October of 02 and made it only active removal. But we also had the seller warranty or the as-is provision, and those were each check boxes. So you could, you could say that the seller warrants everything, for a period of time after closing, versus the as-is clause just said, that everything will be functioning at the closing bell. Okay, that kind of thing. So that's all that does. It's nothing, like I said, major. Not a whole bunch, right? No big changes to. I think we did. Did we make any changes to arbitration? No, we did not. I guess I would be a confident resource on that, right? As I am the chair of legal affairs. I'm very excited about that, folks. I can't even tell you. That's so kind of them. So then we have our assignment of agreement addendum. And again, it's easier for me to show you with the red line version. So I actually, so remember in the purchase agreement prior to, when was it that we added assignments in there was, I think 2016. And one of the reasons that we add the assignment clause to the contract was because contracts are freely assignable at law. We do them in commercial all the time, right? But people were starting to do them in residential, totally, completely legal, right? And so we realized that since people were doing that, we also saw them creating their own forms or their own contract clauses or language. And we said, we don't want that. We want to create a standard form that they can use. And so we added a paragraph about assignment of agreement, and then later on in the next iteration of the contract, we put a time limit on it. So so it went from contracts are assignable. However, we're going to make it so that the seller has to consent to it. They don't have to, but then we said because we're not going to restrict it contractually, we will restrict the time period. So I get them all the time where the contract says they're going to do an assignment. I'm going to go ahead and modify that. Our template says within 0 days. So our buyers are not flippers or anything like that, and they're not going to be assigning the contract to anybody. And so if we come up in a situation where our buyer does want to assign the contract to someone, we owe it in all fairness to the seller to let the seller know at the time of the offer that in fact they're going to flip it. Okay. In the old days, when we had the wood destroying pest addendum form, and some of you will remember that, we were conscripting the seller to do pest control, termite work, dry rot, the fungus among us, all that stuff. We were conscripting them at the time of the offer, and it created a lot of lawsuits because the sellers would come back later on and say, I didn't realize it was going to be what I signed. I didn't know it was going to be that expensive. And then if you're not going to pay for it, then I'm suing, the buyer's going to sue. I had quite a few lawsuits, I made good money off of that. I mean, it was like, I told people all the time, you got to watch out for that. So be careful. You have to understand your forms. And I'm saying this to you, I'm preaching to the choir because you're all here today because you want to understand what these forms say. And so now my assignment of agreement was an addendum, but remember, an addendum adds to things, an amendment changes things. Okay, so a significant change. Hey, guess what? That's what that's what law school says. Law school says an addendum adds to something, but an amendment changes it. But we had just blanketly used the word addendum to all of our forms that were really amendments, and so that's one of the changes that came in here. So you can see the revision date 6/23, and so notice again, and this is a real surprise to some people. You don't have to do a full assignment. You don't have to do a total assignment. You can do a partial. And folks, you would agree with me that you do them all the time, right? Husband writes the offer on the property, and then we add the wife later, or frankly, we've removed somebody from the offer, and so that's what this form is going to be for. All right. So we're going to see here, new buyer replaces all the original buyers. That's going to be in a total assignment. Buyers assigning all of their interest in the agreement to the assignee named below. And then we also have other assignment, which is replacing a buyer and at least one original buyer remaining. So again, husband and wife, whatever. Or we could be deleting a buyer. So either somebody is being removed, is assigning all of their interest to the new one, et cetera, et cetera. And then we give the assignees names. And then E was a good addition in the last version of this. S&E is buyer's own trust or a wholly owned entity of buyer, because you all know that a lot of times our buyers were buying properties in trust. Right? They wanted to buy it in a trust, but the trust could not normally get financing. So what would happen is the lender would do the loan for the buyer, and then we would just do an accommodation at closing, putting it into the name of the trust, right? Because we know that it's the same thing. Right, so that's why we created that part of the agreement earlier. Okay, so those were the big changes. That was page 1, and again, we changed the we changed the name to an amendment, and then again, the seller can not agree to the assignment. So their right to disapprove is going to be on terms. They have to do it. It has to be with cause, right? And then again, time period, which you can change, right? So again, I changed the time period to 0 for purposes of our offer, but for purposes of our seller counter offer, I've already created the seller counter offer, which says that that clause is removed, because we don't want, my sellers typically don't want an assignment. So but if they did, we would just remove that paragraph from the counter offer form. Does that make sense, everybody? I want to make sure that I'm clear about how I'm doing that. And again, I'll send all of this to you if you want all this stuff. I'm going to load the webinar up onto the YouTube website this evening, so you'll have it. But the forms, if you want the red line version of all these things, send me an email. I'm more than happy to share everything that I'm doing here today. Okay, so that's my assignment of agreement addendum. Again, the red line version. I'm not going to pull up the version in the zip forms program because it's just redundant. Okay, all right. So then we have this is a new one. So I really didn't pull out a lot of rental property owner tenant forms, but this one's kind of a favorite of mine, and this is essentially for a lease or a rental, but it could also be a lease after sale. Okay, so the seller is going to stay in the property after closing for more than 30 days. That would be my RLAS form. But because they're really becoming a tenant, and essentially a tenant at will, right? They're there for a lawful purpose. If they weren't there for a lawful purpose, then they're a holdover tenant. Then they would be what we call a tenant at sufferance. Okay, so you don't need to remember all that. Anyway, this is the old PET addendum. So it was the PET form, which we've eliminated, and now it's the ATCA, the Animal Terms and Conditions Addendum. And we can see that we went to blue ink on these. Tenant represents that the animal is a qualified service animal. Again, I think this should have been under new forms, but okay. And under California. So in other words, they're saying it is a qualified service animal. Tenant's been previously asked, represents that the tenant or occupant has a disability. Remember, you can't ask the person, it's against the law to ask the person what their disability is. They tell you have a disability, we assume they do, and the animal is, but we can ask what the animal does. Okay, so the law is kind of tricky that way. You gotta appreciate it. I love the law. I mean, it's like I said, it's I'd rather handle the problem before it becomes a lawsuit. So again, please, if you have questions, feel free. I spend a lot of my time, I probably spend half my day on the phone with lawyers who are having problems. In fact, I had one just 2 days ago. The lawyer's having a problem. I had to refer them to another lawyer because it was really a legal thing and it wasn't within their field of expertise. So following disability-related tasks, tenant is not obligated to complete the following field as applicable if the disability is obvious or an animal's disability-related task is obvious, that kind of thing. Okay, so or B, it's a qualified support animal, emotional support animal, or companion animal. And so, as you probably know, those are. I did it again. Sorry. Those are different than a service animal. And I actually have. Oh boy, do I dare try to go get it for you? I actually have the new law on service animals and these kinds of things. Okay, so again, send me an email, ask specifically for it so that I remember what it is you're looking for. Or C, the tenant represents that the animal is a pet because oh yeah, that's right, that's what we started out doing, was just defining what a pet was, right? So it can either be a service animal, a support animal, or it can be a pet. Okay, and so then we get into the, you're not allowed to have any pets on the property other than those designated above, including any pets that are just visiting. I always like that, just visiting. My boyfriend is just visiting. He's been here for a year, but okay. All right. Let's see here. Not that the boyfriend's a pet. I don't know. Tenant represents to the housing provider. Again, that's our replacement language. That the animal is housebroken. You don't have to take them; they're not housebroken. Has no history of causing substantial property destruction. We have to be reasonable, right? No history of serious threatening or causing harm to persons by biting, scratching, etc., etc. We don't have to create an unsafe condition to support the service animal, if you follow what I'm saying. Okay, so this is real important, folks, because I had a broker call me who owned a property in Oceanside, really good broker. I like her. I've known her for probably 40 years. She calls me up in a panic and she says, I had a tenant on our property in Oceanside, and the tenant brought an animal. And I won't even say what kind it is. Everybody gets all crazy when they hear what kind it is. So it was such an animal, and I go, okay. So you get rid of you can evict the tenant because is it a service animal? No. So then I would say notice to cure, which is get rid of the animal. Well, before she had a chance to do all this, she says to me, she says, by the way, the pet killed the neighbor's service animal. And I'm sitting there going, that's a good one. So essentially, the animal killed the service animal of the neighbor. And by the way, a service animal is not a pet. Okay, a service animal is an extension of the person at law. And so, needless to say, I said, I'm thinking man one, right? But anyway, we got it, kicked it up to an attorney that specialized in landlord tenant, or I guess rental property owner tenant. And they took care of it. So again, I have a whole list of attorneys that I refer to, anyway, so that's my ATCA form. So I like the form. I think it's good. I suspect we're going to modify it some more a little bit later. Okay, everybody good with that? Let's go on now to the bed bug disclosure. Again, I was loading forms that I didn't necessarily need to load them all, but the bed bug disclosure is the law. It is Civil Code 1954. Okay, so and it's included in the lease agreement. So if you're using CAR's lease agreements, it is attached to it. Okay, so there's no way around it. You must make the statutory disclosures, right? You may not waive a statutory right. And then it goes in. We obviously changed some name. We added that residential lease after sale. We changed housing provider from landlord or management company. So the rest of it, all of these are, I was using this as an example of all the changes that we made based on landlord. So we just went through and we just said, everywhere you see landlord, change it to housing provider. Okay, and that's what you see right there. All right, and then we added the housing provider signature on the bottom of the form. Everybody good with that? I told you that was going to be easy, right? Okay, so moving forward to my next one. Aha! I like the new counteroffer form. I think it's a little verbose, and I say that with all due respect to Neil and Matt and the attorneys that I'm very friendly with. I'm very friendly with them, but boy, do they do a good job on this. So what did we do? In June, we changed the forms. Again, we added paragraph C to explain the appraisal gap. So if you remember in your purchase agreement, it says in the purchase agreement that the buyer can say, well, first of all, the default language says the property has to appraise for what we're paying for it. If it doesn't, buyer walks, right? Buyer, I shouldn't say walk because that may be an ADA violation, but buyer doesn't have to perform, okay? Especially if you've got an FHA or a VA, which is going to require the amendatory clause, then there's no obligation on the buyer if the property doesn't appraise for the value that the buyer's offered to pay for it. Now, however, I'm going to add a little caveat to that, and that caveat is that if the parties have done an appraisal gap. So, for that, I think I'm going to pull that up. I'm going to pull up my purchase agreement. I want to show you. If anybody sees it before I do, yell. Where's my purchase agreement? Should have been up there at the top. My RPA. Hello. Did they change it? No. All right, let's do this differently. I'm going to go back over to June of 23, and I'm going to type in RPA, and there isn't one. They changed it. Okay, so where are we going to go? I'm going to get out of this, and I'm going to go to my RPA. Did they change that form? No, it's in there. Okay, I just have it in a different place. Darn it all. All right, so it's going to be up here under purchase agreements. There we go. Because they actually did not change the form, and I'm going to show you that. We're going to discuss that in a few minutes. But here's my RPA. And I want to go down to my paragraph that we're talking about here, which is the loan contingency. So you'll notice on 3L, my loan contingency, yep, you can see that. So I use for laughs and giggles in here. This is my example of, our purchase price was $1 million. And so the buyer and the seller are thinking that maybe we're overpaying for the property. However, assuming it's not going to appraise for $1 million, but it only has to appraise for $800,000. So that's what I check as my example of the class, because I teach this class all the time. But my example was, as long as it appraises for $800,000, then I'll buy the property. Now, again, that's at the agreed price of $1 million. Part of the problem was that the parties would counter offer, and then they would come back at $1.1 million or $1.2 million or $1.3 million. But we had not changed this language, so we left this at 800. So under the $1 million versus 800, we had a $200,000 spread. So if it appraises for 800, the buyer would have to still come up with a 20% financing for the lender, but then the other 200 to make up that difference. That's called that gap. Okay, is everybody good with that? I want to make sure we're clear. All right, so and of course we never remove appraisal contingencies. Don't want to do that, but maybe we can change that and modify it so that we're going to account for that appraisal gap. So I wanted to show you that because I want to take us back to the seller counters us. And then the buyer counters it again. So this language is going to be the same language we're going to see in the seller counter offer. So here's what it says. It says, such as paragraph 3L2 of the RPA, right, which is what I just showed you. Okay. Unless otherwise agrees, if in the original offer the appraisal contingency amount is lower than the original offer price, so 800,000 versus $1 million, then the dollar amount of any difference, that's my appraisal gap, shall remain unchanged and be deducted from the final contract price to create the final appraisal contingency amount. So in other words, if there was a $200,000 gap and now we've gone up to $1.2 million, we're going to raise that contingency so that all the buyer had to come up with was the original 200 grand difference between the original asking price and that 800,000. Everybody good? Okay. So for example, and then they go through the whole example, which I think I probably would have done a Q&A on it, but all right. So if the purchase price in the offer is, oh, look at that. I think they're watching my webinars. So the original purchase offer is $1 million, and the buyer reduces the appraisal contingency to $950. Okay, they're being timid, but I did 800 as an example, because here's the problem. Your buyer may have enough for the $800,000 loan amount. 20% of that would be 160 grand, and then they have the additional 200 to go from 800 to $1 million. So now they're going to have a $360,000 deposit or down payment that they're going to have to make. $160,000 down payment, $200,000 additional deposit towards the transaction. And so all CAR did was make it 950 instead of 800. So then the appraisal gap in their case is 50. Under mine, it was 200. If the purchase price is increased to $1.2 million, okay, here we go. As a result of this counter offer, the appraisal contingency value shall be adjusted to $1.15 million. So in other words, that difference stays the same from the original offer, because otherwise, if you go to $1.2 million, and now under my scenario where you've got an $800,000 loan, appraisal contingency amount, now they got to come up with $400,000. And so unfortunately, we were getting in trouble because we weren't telling the buyer that. We just assumed the buyer had $400,000 more in addition to the 160 they had to come up with to get the loan, because it only appraised for 800,000. Okay, now this is not outside of the world of possibilities, folks. I've seen some insane offers recently where buyers are paying $500,000 more than the appraised value of the property. And so we had to create such a contingency just in case, okay, or a clause, really. So So that shows it with so again, since the original offer was $1 million and there was a $50,000 gap on your screen, right? You can see that, yes. And now if we go to $1.2 million, then the contingency value is going to be $1,150,000, which means just the 50. It'll stay the 50,000. Okay. If the property appraises below $1,150,000, buyer may exercise the appraisal contingency right to cancel. Does everybody get that? Okay. All right. Okay. All right. And that's all that says. And then we're going to cover that again in a minute when we get to the sellers. We'll look at it. We're not going to spend a lot of time on it because I think I've already explained. Does anybody have any questions about any of that? Seeing none. Okay. My Buyers Homeowners Association advisory, and I just threw this in here. There's a couple little things, but again, you're further advised to carefully review the prelim. See my class, how to read a preliminary, my award-winning how to read a preliminary title report class. Remember the field case, everybody, because that came out of Otay Water District here in San Diego, and that's a big appellate court decision that you need to be reviewing the prelim with your buyer. So to determine all the recorded documents related to HOAs, which could include but are not limited to deed restrictions, and then existence. Is that how you spell existence of multiple HOAs? I should probably write that down. Little things like that. All right, sorry about that. So this is going to be my BHAA form. And this is existence. Okay, good. All right. I see these mistakes, and then I have to help them out. So covenants, conditions, and restrictions, my CC&Rs, main governing document, and so that goes into explanations. Anyway, good form. I like the form. Financial information, et cetera, et cetera. So this is a lot up there with what I talk about, which is reading them their rights versus I told them something. Whenever there's going to be a dispute between the client and you're going to lose. All right. Not every time, but in most cases, if it's a he said, she said, my word against theirs, then there's probably going to be I'm probably not going to be successful. Why? Because plaintiff's counsel, that's the attorney for the buyer, normally will have professional up on the board in 10-inch bold letters for the jury to see. And then all of a sudden, that's the only time I ever hear, or not the only time, most of the time, it's the only place I ever hear of a real estate agent being referred to as a professional. Normally they I want you to cut your fees, and I don't think you do anything anyway, and all that kind of stuff. So, but anyway, trust me, they make a big deal out of it. Okay. So such litigation may also impact the willingness of lenders to make a loan secured by the property. These are all things that we all knew from years and years of doing real estate, but we just never really verbalized it with the client. Now we have them sign a form that and here's my special needs. HOA documents may limit the number and size of animals. And so there may be limitations on what they can do. Okay, so has everybody got that? That's actually a pretty good form. So that's my BHAA form. Questions? No. Let's move on to my burn form. I like the burn form, and it was revised, but as you can see, 1786 with proper identification are entitled to fill out from a CRA, which is on file. And so, we're not going to turn over your credit report or what company we use to investigate you, just on your say-so. We're going to want to have proof that you are who we're sending it to. Okay. By the way, I'm writing a letter for the Department of Real Estate right now on trusts. I've done a couple of transactions recently where the agent on the other side insisted the seller was TDS exempt. I've been asking for documentation that the seller was TDS exempt, right? Because it really changes, and it's a legal decision, right? It's a legal decision whether or not the seller is TDS exempt. And so I'm putting it up in front of the Department of Real Estate, and then I'm going to provide them with cases. But the bottom line is, just because somebody signs the trust advisory does not mean they're TDS exempt. Okay, so be aware, it's coming to a theater near you. So anyway, that's my notice regarding background investigation. This is usually on your rental properties, that kind of thing. Okay, and then next question. But I did want to bring that up about the trust, because probably more than half of our transactions involve trusts in San Diego County for sure. Okay, all right. And again, this is when I was going crazy, just trying to load these forms as fast as I could before class started. But this is my listing agreement form. And again, they've added a bunch of stuff in there that I think is pretty obvious. I'm going to skip that one because we're going to talk about the RLA in a minute. Then there's one of my favorite forms, which is the buyer representation and broker compensation agreement. I don't know what the problem is with me, but I've never had anybody turn me down. It's just crazy. So, okay, maybe I'm just brave and I ask for stuff. So anyway, this is the form that replaced the BRE form. Actually, the three forms, right? We had a BRE, a BRN, a BRNN. They were the equivalent versions of the listing agreements. And so we created one great big agreement. My hat is off to Kathy Maringer, who was the head of this task force, as well as the task force that got rid of the WPA. I'm so proud of her for doing that. God, did we need to get rid of that form? Again, I made a lot of money off of it, but it was just getting us sued because we didn't know what we were doing. So here's the form, and I don't recall if there were any changes to this version. They did not give me a red line version. Look at that. Wow, no red line in there. This was a brand new form at the end of last year. They did not give me a red line version. Look at that. So this was the form as of the end of last year when we created the original. So it shouldn't even be in the discussion because it's not a new. It was a new form then. It's not a new form now. But I love the buyer representation agreement, folks. I use it all the time. And along with this and I have agreement signed with the buyer. Buyer agrees to compensate me for my services, and then I ask the seller to pay the buyer's obligation to compensate me, and that's going to be my SPBB form, and we'll talk about that in a few minutes as well. Made a couple of changes to that. So that's my buyer representation agreement. Again, 2-hour class. I know you don't want to have to listen to that right now. I just cannot believe how fast the clock is going here. Cancellation of contract. Now, this was a huge change, right? So remember, folks, you create the contract between the parties, right? The buyer seller normally, you create the contract, but you also create the joint escrow instructions. Okay. Now, in the old version of the contract, the one page, which I love to bring up and show everybody, the one page version, it was called residential purchase agreement and receipt for deposit. Well, we don't take deposits anymore. So now we have I'm sorry, it said residential purchase contract. We don't say contract anymore. I only use the word contract when somebody's trying to get out of it, right? I'm going to call it an agreement until that time. So the current form says residential purchase agreement and joint escrow instructions, because we have also created the escrow instructions, because not that long ago, we would have escrow create a whole new set of instructions based on what their interpretation of our contract said, and then there would be a dispute between the escrow instruction and the contract, and then which one prevails and all that kind of stuff. The contract prevails. So now when we cancel the contract, in the old days we would call escrow, say send out cancellation instructions. Well, that only canceled the escrow. It did not cancel the underlying contract between the parties, right? I mean, they try to do that, but that's not what our contract says. So now this says, hey, we're going to cancel the contract. We're going to tell everybody what we want to have done with the deposit, but we're also going to cancel escrow, which is something that we were missing, right? We need to make sure that now we take escrow off the hook, because escrow was always happy to send out cancellation instructions, and they didn't want to be involved, in a potential lawsuit. Okay, so here's my advisory and instructions. Again, parties canceling is required to act in good faith, right? And so it has to be and good faith was added to the contract back in 2012, okay, in October of 12. I remember David Bright, who is an attorney up in Escondido, and he made a great comment in a meeting I was in with him, and he said the addition of good faith is going to change all of our litigation, right? So in other words, did you have a real good reason for canceling, and is it a legitimate reason? And I think he was dead on. In fact, I'm gonna probably try to call him up and just thank him again. Hell, that was 20 or 10 years ago. But disputes over cancellation deposit can be complex legal issues. You never want to tell your buyer to get their deposit back. You never want to tell the seller they're going to get the deposit. Agents are not qualified to provide an opinion. It's a legal opinion. on who's entitled to the money or whether or not cancellation was made in good faith. I love that in bold print. Buyer seller advised to seek the advice of a term that CAR coined recently, a QCREA, which is a qualified California real estate attorney, a QCREA. They did that. I had people call me up and they said, well, I talked to my attorney and they said this. And I said, really? I mean, I teach attorneys this stuff. Where's your attorney? Oh, they're in Illinois. And I always say, did you tell them we were asking them a California question? Because it could be disbarred for that. I mean, lose their bar. Okay. Bottom line was, you need to talk to a qualified California real estate attorney. And again, I've had so many lawsuits where they hired a general practitioner who just wasn't as familiar with the contract as a real estate attorney would have been, right? And so, needless to say, I've been successful in every one of them. Party canceling agreement and not the agent needs to determine if a cancellation right applies. So it's not our job to tell them whether they have the right to cancel. So this is why I ask you to read the forms, everybody, because we talk as if we've never read the form. So we tell the buyer, oh yeah, you can cancel. We tell the seller, yeah, you can cancel, but we're not qualified to do that, right? So it must be exercised in good faith, et cetera, et cetera, et cetera, and only after notice to perform or demand to close escrow, right? So blah, blah, blah. If there's an open escrow holder will need mutual agreement. So this is instruction to the parties that sometimes we get tongue-tied and we don't say it quite right. If the parties are canceling the agreement but are disputing the deposit, then the partial release section can be used in paragraph 2D. I had that lawsuit as well. I got called by a seller to come out and list their house. And so I went, right? The seller can solicit me. I knew that they were currently listed with another broker, a friend of mine. And so I got there and I said, I just want it on the record. You called me because, I may not solicit the listing of another agent. It's a tort. It's called interference with contract, right? And so the seller says, no, I know, but here's what happened. So the buyer was all the way through all the contingency period. They're ready to close. And then there was a rumor that went out that the Del Mar Fire Department was going to relocate their firehouse right across the street. And so the buyer said, I'm not taking a chance. And so the buyer said, I'm canceling the contract. So everybody was smart. They all realized we can cancel the contract. Now the lawsuit is just over the deposit. Unfortunately for the buyer, of course, Mrs. Seller happens to be a practicing attorney and a good one. But I knew where that was going to go, but we were able to go on and sell the house, even though they were suing each other over the deposit, or the seller was suing the buyer for their deposit. And so, folks, you don't want to give people advice on something and then find out you are just categorically incorrect. So if you get a question that's a legal question, you need to learn, first of all, please speak to your broker unless you are the broker. And we've got quite a few brokers on the call today. But if you are the broker, you can always call me, I guess. I'm not going to give you legal advice, but I may have an attorney to kick it up to. But at the end of the day, they need to be talking to an attorney. And again, as I said in the beginning, I'm not an attorney. I can't give anybody legal advice. I can just give you practitioner's advice. Okay. So again, parties are advised to consult a qualified California real estate attorney. Damages and remedies, and by the way, when you tell the buyer, well, your limit of liability is only $3,000. Remedies, folks, is a year of law school, and we never even talked about the California purchase agreements or any of those things. Remedies is a year of law school. That's how complicated the issue is. And I talk to attorneys all the time. They say stuff, and I go, I remember that. So be aware. You shouldn't be giving anybody any advice on what they can get away with. Okay. All right, and so then no real changes down in here, but signing this section solely for cancellation of contract. So this was just to cancel the contract. Now we're going to go to page 2 for the deposit and the cancellation of the escrow. No real changes for the disposition of the deposit and the cancellation. There was a change in there that they don't have redlined here. I think we added this last time, paragraph number 2C4. There is no deposit in escrow. Each party to pay their own unpaid contractual fees and costs, if any, already incurred, agreed to in the contract, whatever. So in other words, the buyer, even though they say, well, I don't have a deposit, sue me, they still have costs they may have to pay. Okay. And there you go. And that's my cancellation contract. Again, a great big long story about all that, but again, we have to make sure you're using the revised form. Okay, let's get questions on that. Seeing none, let's go to the next one. Cash for keys. So again, all of this cash for keys is in the new, these are going to be our lease agreements. Typically, whole first page that they're going to tell you to remove from the rest of the agreement because you're going to serve this, right? And the cash for keys agreement is, here it is. We revised it 6/23, offer to surrender the premises in exchange for cash. And I think that was here we go. Yeah. And then paragraph number 7 again, and failure to vacate. What happens if you don't move out after we give you the cash? And then we have our occupants. Okay, so that's pretty easy. Again, that's going to be on the landlord tenant. I'm sorry, the rental property owner tenant side of things. Maybe we'll have to come up with a new name for tenant. I don't know. So a serf or a thief or something like that. Then we have our cancellation of lease or rental, not to be used as a notice of termination of tenancy. So in other words, we're going to handle it completely separately. Again, California landlord tenant, so we didn't change the word landlord, we should have, who's familiar with the laws where the premises is located. I get a lot of calls, and I coach a lot of property management companies, and I can tell you that San Diego law and California law, two different laws, right? I mean, they try to mirror what California is doing, but then, back in May, I think it was the 26th, San Diego passed a new rule on rent control and just cause of their own. Okay, so they cannot make it more liberal than the state rule, but of course it's more defining, more narrowly construed, and so creates really a need to talk to an attorney. Okay, and then housing provider changes and all that stuff. You can see that all the way through here. And there you go. So that was easy, right? So that was the cancellation of a lease or a rental. Let's talk about my cancellation of my listing agreement. And a little bit of a change here. 1A or B or both may be checked. So both could apply. Okay, so we added maybe checked because they both could apply to the cancellation. Then in paragraph number 2, the principal agrees to pay the broker a percentage of the listing or, if applicable, sales price, whichever is greater. And then here are all the conditions that were in the old agreement for that as well. So we just added listing or, if applicable, sales price if they go to sell the property, because your lease agreement usually has a place for, if the seller sells the property to the tenant, for example, then you're entitled to compensation. Okay, so that's my cancellation of my listing. Let's go to my DIA. Not a whole bunch in here. This is my, by the way, this form is a disclosure information advisory for sellers. I want to call your attention to that because I'm going to show you something down at the bottom of the page in a second. And down here, seller property questionnaire. This explains to the seller what the questionnaire does. This includes these things. And defects affecting the value or desirability of the property. That's out of the Easton case. One of the questions on the SPQ and the ESD addresses the seller's obligation to provide to the buyer any relevant documents, including reports, whether past or current. So in other words, we're telling the seller this, okay? And then what am I looking at here? Sorry. This is my disclosure information advisory. Like I said earlier, I've got a couple of transactions already in the last 6 months where the seller is claiming to be TDS exempt when in fact I doubt seriously that they are. And I have yet to find a broker that can provide me with that documentation. So there you go. Do I need to disclose? It's almost always yes, disclose it. So I'm wondering in these transactions whether or not the seller has been provided with this form and whether or not they've read it. Notice down here at the bottom, by the way, so we call this personal to the broker. So the seller is the only one who signs the form. Because we don't need evidence that we if we have their signature, then we have evidence that they signed it. It doesn't go to the buyer's agent. It only goes to the seller's agent, okay, seller's broker, right? So I get people sending me these all the time. I'm like, well, I don't know. Okay, I'm glad you did it, but I don't need it. I'm going to assume you're going to have it when the attorneys start calling. So, okay, that's my disclosure information advisory. Then I'm doing my, then we get to my exempt seller disclosure. And we added this language in here because this is the language that we just added to the TDS. And I say we did because remember, the TDS is a statutory form. It was created by the legislative body. However, we've been going in and making changes changes to the statute. So, you know, we've got good attorneys and they're real estate attorneys, and they're going in and they're rewriting statutes. Your agency disclosure form is a rewrite of the old form that didn't make any sense. The listing agent, the selling agent, nobody knew who those were. The DRE knew we didn't know who those were. So they were testing on it all the time because which one was the selling agent again? Is that the seller's agent or the buyer's agent? So we just changed it into plain English: seller's agent, buyer's agent. Okay. Then we had to renumber the paragraphs. That's all that does. And that's it. That's the whole change to the exempt seller disclosures right up here at the top to make it consistent with the transfer disclosure statement. Okay. So my fair housing and discrimination advisory, I'm looking at this, no changes until boom, I get down to paragraph number 7, and we changed landlord being the housing provider. Again, I think they needed to get rid of landlord if they were going to be consistent. But then they also added a good website, calcivilrights.ca.gov/housing. By the way, the Department of Real Estate has teamed up with the Fair Housing Group. They've got a really good YouTube video. If you send me an email if you want a copy of it, I can point you to it. I've saved it on my computer because I thought it was well done. But listen, they're taking it seriously. They look at other people's stuff, okay, and so they take it seriously, because if you run afoul of that, then they're going to wait until that department is done with you, and then they're going to come after you with the evidence that was procured in that case, and usually that's not a good thing. Okay, if you follow my drift. All right. Okay. So that being said, we have our lease listing agreement. So we'll just cover this really quick here. You know, what are my changes? Here we go. So again, changing things, the rental. So the RPO, that's the rental property owner, agrees to complete a rental property owner disclosure. That's the RPOD, and the questionnaire, which is the RPOQ. I think we should just blend the two forms, but there's some things that we let the owner know that we don't necessarily need the tenant to know. RPO authorizes the broker to provide the tenant with the RPOD, which we talked about earlier, with any lease. Or so again, the questionnaire now is between the broker and the rental property owner, but the RPOD, the rental property owner disclosure, is what we're going to give to the tenant. Okay. That's pretty much everything. We added a place for addresses and emails, which, you know, I kind of was surprised we went a long time without having that there. Let's talk about my lease rental mold addendum and all. What do? We added it to that residential lease after sale again, right? We changed housing provider, right? The landlord became the housing provider, and all of these changes are just the changes to housing provider. Everybody okay with that? Again, I wanted to show you because I wanted to bring your attention to it, but let's take a look at my manufactured mobile home purchase addendum. And I appreciate the fact that you may not do a lot of these, but Joe is the king of manufactured or mobile homes. So I know you're watching. So here's the changes that we came up with. This is the red line version, and here it is in paragraph number 8, which I think Joe and you and I had talked about this one at one point. So we added end park rules for property located on leased or rented land, and then we've got the buyer's approval of the lease or the rental agreement with the park is a contingency of the agreement, right? And then paragraph number B, the buyer's got 5 days after acceptance to submit a completed residency application. Doesn't always happen within 5 days, but it'll sure tie you up if they can't get in. And then paragraph number C, buyer obtaining residency approval is a contingency. So if they, and again, but when you remove your contingencies, you remove this as well. Okay, so such approval shall be obtained 5 days prior to close of escrow. If the approval is not obtained prior to that time, the buyer may cancel. In other words, we had one recently where we were doing a purchase, right, Joe, where the park had taken an inordinate amount of time to approve the buyer, and so the buyer turned around and came to us instead because they were tired of waiting. It didn't get done in time. They canceled the agreement. If they remove the contingency without first having obtained park approval, then park rejects the buyer's residency. Buyer understands buyer may be contractually obligated to complete the purchase, even though buyer may be required to remove the home from the park. Aha, that's significant, right, Joe? Okay. That's my big change. That's my MHPA form. Good. Covered that. Any questions on that? No. Notice to buyer to perform. One of my favorite things, right? In the old days when we first came out with this form, I remember when we first came out, there were all kinds of typos on it, and I remember commenting on it and getting it all fixed. But the when we came out with this form, we would send it over to the buyer's agent, and of course they'd have a heart attack. Really, oh, how dare you? And no, this is part of the process. Remember, because we need to protect our seller, the seller's ability, the seller's right to cancel the contract. And the contract says you may not cancel until the buyer has been given a notice to perform and given an opportunity to do those things. And if they don't do it in time, then fast forward to the next level, right? So if they don't do it in time, then the seller has the right to cancel. They don't have to cancel, but they have a right to cancel. And so, but the important difference here, if for any contingency or contractual action selected, this NBP is delivered before the time permitted in the agreement. So in other words, you had some contingencies being removed in 10 days, others being removed in 17 days, but you sent a contingency removal for all of them, then the ones that were 17 days, that doesn't apply. You're going to have to send another notice to buyer to perform to cover that. So the notice shall be void for only those specific contingencies or contractual actions, and those are the longer ones. But this notice shall be valid for all the others that are selected. So if all contingencies is selected, then it shall be valid only for those contingencies within the proper time period, and then void as to others. And so again, you check the box, all contingencies, but the but the buyer had still by contract had another 10 days to do the loan or the appraisal, then those, and you checked all, then those two would come out of it, and they would have to be served in a later notice to buyer to perform. Is everybody good with that? I'm glad they added that to it, because we were finding ourselves having to explain it when they actually explained it better, I think, than we did. Okay, all right. How about my probate agreement purchase addendum? So a couple of changes in here under court confirmation. Court confirmation within 60 days, we had to put a time limit on it, and it is a contingency in favor of the buyer. And then same thing in where the court confirmation is required, we have the same thing down there. What else? Anything else? Here we go. Even if initialed in the body of the agreement, the RPA, the paragraphs for liquidated damages, mediation, arbitration are deleted from this agreement. Why? Because it's the court. You can't make a court go to court, right? It's enough trouble getting them to show up, right? So if the property is under Independent Administration of States Act and the parties are attempting to modify the agreement to include any of these provisions, they're advised to talk to QCREA again. Okay, everybody good with that? That's a good one. I like it. Good form. I like the form. Okay, let's talk about my PMA, which is my property management agreement. The biggest thing in here, and I know you probably don't do property management, but the biggest thing in here that we changed was that the property management agreement is not binding on the broker unless the broker signs it. So in other words, the agent can sign it, the associate licensee, whoever that is, can sign it, but it's not binding on the broker until the broker signs it. So forget the 5-day requirement that the Department of Real Estate gives the broker to approve or disapprove of these forms. Now we're going to say it just doesn't apply until the broker or an office manager on the broker's behalf signs it. Okay, that's the biggest change, and big print up at the top of the form. You can see a couple little things in here. There's my RPOQ again. Let's see, anything else exciting in there? I thought there was one other thing. Oh, there we go. We've understands the agreement is not binding on the broker unless signed below by the broker or an office manager. So again, the associate licensee, if they choose to sign it, we've made it very obvious that it's going to require the broker's signature to make it go hot. Okay, everybody good? Scrolling back up to the top, that's my property management agreement form. My RCJC. Really, the only changes in the RCJC, again, this was Civil Code 1947. I've done a lot of talks on this. I did a really good one. I thought, not that I was good, but Robert Sunderland, who I think is just a brilliant attorney, and I teamed up and did a talk on when this form first came out, when that Civil Code had been passed. But look at this; these are all housing provider changing the names, the parties to housing provider. That's pretty much, the only thing we've done there. And again, we have our qualified California real estate attorney, because before it said qualified real estate I think it said attorney as well, but that's the whole point behind why they did that. Okay, so then we have our representative capacity signature disclosures. And so these changes are going to be fairly similar across the board. This is the one for the buyer. We've added in there that the seller, we had a place now for the seller to sign it, assuming you use the form, right? But again, remember, if you're doing a purchase agreement and you fill the form out properly for the buyer, you don't need this form. Okay, because that form is included in the purchase agreement. But if you end up using the form because now you've changed it to an entity, then you're going to need this. Just have the seller acknowledge that they're aware that who the parties are. Same thing with housing provider. We've added that provision to the lease agreements now, but we had to put it in here as well in case you're using an old form. That's all that does. Here's my representative capacity for my tenants. So same language in the other one. Again, we haven't changed the name of a tenant yet to, I don't know, maybe we'll call it Bob or something. Here's my residential income purchase agreement. And this one, you know, I'm going to skip this one because I want to talk about the listing agreement and the RPA. So the changes on the residential income purchase agreement are roughly the same. Okay, so here's my RPA. So now again, this is supposed to be the red line version, and I already showed you what the change was that they were supposed to make. You notice I'm not having any red line versions here. There's no red lines in here so far, unless we find one. But I get over here to paragraph 11. Where did it go? Look at that. So this is the red line. This is the change to the RPA. Solar power systems. Now, here's the rub. I'm gonna take you back up to that paragraph 11, and we're gonna see solar systems. Is everybody following me here? And so I'm gonna give them a hard time about that. So anyway, I'm gonna make a note, but again, I say it in jest. I try not to upset anybody, but you know, David Kerr, who headed up the task force on the new RPA, really a really great real estate agent. And whenever I see him, I thank him for the new RPA. I love the new RPA. But notice that they did not change it to solar power, even though in here it does say solar power systems. So, but in the meantime, I guess we could still sell Venus and Jupiter and Mercury and stuff like that. So good. All right. So I wanted to show you that. So let's go back to my share. See anything else in there? Here it is, solar power system. I don't know why they changed it there, because here it says solar power system, but why did they change it over here? I don't know. I'll send an email to Neil, find out what's going on with that. But those are our change. Well, you know, and then down here under prorations, you know, seller rental payments to third parties, you know, some little stuff. You know, we categorize these little changes under soft publish. A lot of times, this is why I tell you it's very important to make sure you're using the current form, make sure you're using a template, because we'll do soft publishes, which means we'll change something and then nobody will notice it. But if you're using an old form, you know, would it have any significance in your transaction? Probably. So I would advise, you know, making sure, I'm going to fly down through here just really fast. Oh, this was the other change, was my possession. So in a residential income purchase agreement, vacant units are either to be delivered vacant or you take them subject to the tenant's rights. So, and then again, seller occupied to be delivered vacant. So we want the seller to move out of the property at that point. Remember that the new contract says that the buyer needs to be providing the TOPA form, the tenant occupied property addendum form, but it's in the contract so that if the buyer's agent doesn't provide it, it's a warning to the seller and the seller's agent that they need to prepare it, to provide it. Occupancy on my RIPA, seller shall disclose to the buyer which units are occupied by the tenants, including any adult other than the seller. If a tenant occupied unit is to be delivered to vacant or elsewhere, such as in a counter offer, seller is responsible for delivering the unit vacant. Occupancy may impact available financing, obviously. So if the buyer says, I'm going to be occupying unit number 2, then the seller has to make sure that unit number 2 is vacant. Okay, all right. Under title, we added preliminary title report I think it just kind of went without saying, but it really needed to be said. We talk about it as a prelim or a PR, and again, see my Q or my webinar on that. Anything else in there exciting? We're almost done, folks. Probably gonna get done a couple minutes early here. I think that was the majority of stuff. There's my solar power systems again. Oh, unearned rent. So security deposits and unearned rent. So where does it say here? Seller, in accordance with a rental agreement and current law, all prepaid but unearned rents, if any, shall be transferred to the buyer. And then seller shall notify each tenant regarding the security deposit that the new person has it. That's good. And let's see, anything else exciting in there? That's everybody. I do like our new purchase agreements. I really do. Much easier to defend. Well, I just saw something. What was it? Nope. No. Okay, that's everything on my RIPA. Let's talk about my RLA, my listing agreement. Let's see what the changes are going to be to that. Again, status quo until, except now it's going to be 6 pages. So we've added smart home features. And so you'll see that in the newer version of the RPA in the got lost already what I was talking about. Smart home features, yes. So that's in your new purchase agreement, and I'm going to pull that up separately for you to see it. So again, as I said earlier, you're not getting the you know, the red line versions are really great to have, but oh gosh, now I've completely forgotten what I was talking about. Going back to my document, which was my RLA paragraph there. So I'm going to go, where am I? I'm in, this is the wrong form. I needed the RLA. Okay, don't try this at home, everybody. 6/23, notice my revision date. All right, I'm going to go to full screen. And again, this is possible representation. The smart home, there it is. So paragraph number 4C. So this is what it's going to look like in your form. So you wouldn't know that. And I understand a lot of people just kind of hoof it when they go on appointments, but you really need to know these things. These are important things that you know that the form has changed. And this is why I tell people all the time, don't speak against the form, because you know, if you haven't read the form, then it's going to be a surprise to you. And I always say that the best time to read the form for the first time is not in front of the client. You know, I really think you should look at it ahead of time. The good news is that most of our changes, you know, again, we only had 4 new forms, of which you're probably only going to use 2. What the hey? Thought for sure I turned that ringer off. I apologize, everybody. I just have way too many telephones. Boom, boom, done. I don't know why my people call when I'm in the middle of the thing. Seller's election to opt out of features. We've added that language down here, presentation of offers. So now we're actually going to talk about strategy, different strategies for obtaining the best offer. Sellers advise that certain buyers may prefer not to be in a competitive situation. Yeah, we need to tell the seller that, you know, writing a multiple counteroffer may kill the other buyers. So anyway, lots of really good. Do I need to address anything specifically? Sellers advise that certain buyers may prefer not to be in a competitive situation and either may not make an offer, or if there's an instruction that all offers be presented at a later specified date, which, by the way, I've never seen that in a listing agreement. You know, usually the agent has it in the MLS, but when they subpoena the listing agreement, it's not in the listing agreement. So folks, be very careful when you're putting language in the multiple listing service. Make sure that you can refer to it in the listing agreement. So your listing in the MLS needs to be a mirror of your listing agreement with the seller. And so, like I said, I never see this language in a listing agreement when the listing agreement gets subpoenaed, but I sure do see it in MLSs all the time. So, you know, your decision that all offers will be presented by, you know, on Friday at 5. needs to be the seller's decision, not yours. Okay. All right. Sellers advise, discuss, and consider the best strategy. Seller instructs the broker to present offers, which is what we want them to do. Or the seller says, don't give any offers until a later time. Now we've given you the ability to create that so that you can, now you can do it with the backup of the listing agreement with the seller's permission. Okay. All right. Questions about any of that? I think that was the bulk of our changes. Again, we've added address and emailed all the signature lines. Okay, gonna get rid of that. Any questions? I'm sorry. No. Okay. All right. Take a look at my SBSA. Just when you thought that that was one of the longest forms that we had, legal, tax, and contract considerations for both the buyer and seller. So I actually have in my signature line that working with me does not constitute tax, legal, or medical advice. I actually put in medical advice because I made a comment in a class one day that I tell people to take a baby aspirin before a test, and they said, "Well, that's medical advice." And I go, "Oh, you know what? You're right." So anyway, in order to fully understand, contact a CPA or tax attorney, or I've got an excellent EA, enrolled agent, to determine all of these other things. We can't advise them on taxes. I think we get into a real bad spot when we're helping somebody do a 1031 tax deferred exchange, because now you're probably going to give legal and tax advice. And so be really careful, folks. Make sure you're talking to your broker. So we had a couple of other things in here: electrification of energy source. We've added preliminary title report, solar panels and net energy metering. I'm trying to talk Melinda into solar power, but unfortunately, I'm trying to talk her into putting it on her house. So that's not going well. Here's my explanation of the prelim, which nobody tells anybody. I had a guy call me. I was having dinner, and this guy calls me on the phone, and he says, "I just watched your webinar on the preliminary title report." He says, "That's the best thing I've ever seen." I said, "Well, thank you." I says, "Who are you?" And he says, "Well, I'm a buyer in a transaction." I went, "Uh-oh." So they're actually finding my webinars online, folks. He said his agent couldn't explain it to him. The TO wouldn't return his call. These are important subjects. And so I said, I really can't comment on your transaction because I'm not a party to it at all. And again, I don't have expertise in that area, right? But he said, I got everything I wanted. So, wow, really? So if the public is saying that, then, maybe take a look at that. And I redraft it every time I do it, only because it's a fairly complicated subject. But you can see there's not, there we go, electrification of energy source. So several local jurisdictions in California have enacted laws which prohibit the use of natural gas appliances in new construction. So we're going all electric, and then I'm having a problem with what happens with the grid, right? And I think that we're pushing people into what's going to cost us more money. I don't know. Some are considering bans, et cetera, et cetera. And that's what that's going to do. And then what else? Here we go. Again, these are my CC&Rs, so HOAs and charging stations and FHAVA approval. So although unenforceable as possible, the CC&Rs. And again, this is, I remember I had a TO from one of the title officer from one of the title companies come talk to my law class about title policy. And he actually brought in a title on a property in San Diego. The title actually said there were ghosts in the property. So you'd be surprised what you see in these things. But for them to put that in there, it was an old document. It's 100 years old. But we need to know that any reference to anything, any violation against a protected class, and it says right here, race always, right? Religion, other protected classes or characteristics. And so California has 22 protected classes. I mean, pretty sure they're the most in the country. And the very last one, number 22, says any arbitrary characteristic. So it's like, okay, so pretty much everything, that's going to be the bucket list. So just be aware that anything on a title, anything that comes from title that says that is a violation of any of these things is just going to be a void. But again, we've got a really good Q&A on that, our quick guide, we're calling them now, okay? But they're just void. See, the real issue is, can your buyer cancel the transaction based on something that's in there? And I'm not going to do a class on this right now, but there are some ugly things in some of these restrictions that the city put into place. And I'm not just talking about the city of Del Mar. So solar panels and net energy metering. Can you sell your power back to the utility companies, that kind of thing? That's it for that form. I did promise you the seller counter offer. Here's the language that we saw earlier in the buyer counter offer form, so I'm not going to spend any time on that. And then my solar advisory and questionnaire. This is another one of those forms of what took us so long. Solar power systems. We replaced all of the solar systems with solar power systems. We didn't do it in the RPA. I guess, I don't know. I think somebody just forgot, but look at all that. This is all just changing it to solar power systems, really pretty much for the most part, everything, right? And then here's my Q&A, again, based on the format of the SPQ, which I think this is what a great job on this. And Adam Peck, who's a real estate broker in Del Mar, pushed for this for the longest time, and we finally got it through. And I do need to follow up with him and see how he likes the form, because he may give me some more suggestions. I'm going to make a note of that. So I'm getting in the habit of making notes when I do these classes. So, okay, that being said, we're almost done. SPQ, again, language up here at the top, much like what the TDS says. I think I'm going to show you the TDS in a minute, but that was, okay, a couple of little things on title. And again, this is the SPQ, so this is the statewide version. Our SPQA has changed as well. Be aware of that, folks. There's some really good risk management forms in the San Diego library. So seller's purchase of replacement property. I personally think you should use this in every transaction where you represent the seller. And that's because unless your seller is going to literally be homeless or be willing to live in their van or something, what happens if they can't get the house that they're selling to get into? And so that's what this form is going to cover that. Removal. So buyer's right to cancel, seller's right to cancel have changed a little bit. So we have to give notices to perform before we can cancel. And I already talked to you about that earlier today. Here's my TDS. There's the changes across the top of the page. Again, consistently also in the SPQ. And that's it, right? Okay, all right, so I'm gonna get rid of that. And then finally, my tenant occupied property addendum. So again, some big changes there. So paragraph number 1B, if the property is going to be delivered vacant, then seller within 5 days prior to closing shall deliver to buyer the known names of all adult occupants other than the seller residing in the property. So, supposedly it's going to be vacant at that point. Even if, pursuant to the agreement, seller remains in possession after closing, no tenant shall remain. So, in other words, we're closing the loop on all those things. So, again, I like the new the tenant occupied property addendum. I think it's a great form. And as I always say in my classes, here we are in paragraph number E3, tenant estoppel certificate. So when you take a listing with a tenant in it, you need to get that TEC completed by the tenant and the owner right away. Because I'm looking for it when I write the offer. I'm going to want to have a copy of that. And tenants are much more cooperative at the time of leasing the property. Maybe the seller didn't anticipate selling it, but if you've got that TEC form, then you've got something that you can defend. Okay, so getting rid of that. Let me take us back to the PowerPoint. We can wrap this up. So we talked about all those things. Thank you for joining us. If you want copies of the new and revised forms, there is a link included in the newsletter. So if you're getting the newsletter, just click on the link. And then if you want to view any of the previous webinars, get your QR code reader ready. You just take a picture of this with your phone, and then you'll have access to it. You can also type in your browser, just type in @Burke Real Estate Consultants Inc. And I did all this, I created all these things because the DRE is requiring me to do it because I'm going to be doing the RPA class, and they want people to have access to the forms ahead of time. So the forms being the form for the class, not necessarily the forms in the class. So I had to create a place for that. We also have a bit.ly link. So thank you to Andy Kerwin, our marketing director, who created the bit.ly link for us. Case is important. So bit.ly/real-estate-ed. And then, whoops, question, Kevin. I would like to have this class information on documents. Your best advice for which I should have this class information on documents. Joe, I can send you all the documents if you want. I'll send you all the red line version. I think that's what you're asking me, right? And then you can always click on the link and go to the webinar too, and then you can follow along with it, like I was showing you in this. Is that okay? Please remember to like and subscribe. I was just really honored. I went in the other day and I found all these people were liking it, and I thank you very much if you've done that. It makes me feel good. I mean, I don't get paid for it, but it does make me feel good that you liked what I did. And then subscribe. If you subscribe to the at Burke Real Estate Consultants Inc., all that does is notify you when you log into YouTube that I've updated the webinars. That's all. They don't email you. They don't do stuff, so it'd be nice if you would, because I want you to have the current versions of everything. If you've got anything you want us to talk about, education, SDR, I know SDR is focusing pretty heavily right now on Tom Ferry, which, and I like Tom a lot. He's good. But I think we still need a lot on the practitioners level of things. And so we'll see how that shakes out. Again, I have weekly email updates. If you aren't getting the email, send me an email. I'm more than happy to update, get you on the list. But you have to specifically ask to get on it. I don't just put people on it. Everybody's opt-in, and I've got a lot of people on it. I've got a 60+% open rate. So a lot of people open my newsletter. So if there aren't any other questions, I'm very excited that you were here today, and I thank you profusely from the bottom of my heart, from the top of my heart, wherever you want to start. Oh, Linda signed off. Okay, so I'm just watching. Okay, so thank you all. I very much appreciate the value of your time. If I can do anything for you, please reach out. Let me know. Email is usually best. But if there aren't any other questions or comments, then again, I thank you all. Oh, there's one. Thank you, Joe. You're very kind. Great class again. Thank you very much. And so, as we say from my hometown of Del Mar, I look forward to seeing you around the track. Thank you, everybody. Have a great day. Take care for now. Bye-bye.